The Supreme Court appears to be expressing concerns about how lower courts should handle President Trump's executive order on ending birthright citizenship. Yesterday, justices heard oral arguments on a series of Trump's emergency requests that seek to limit the scope of nationwide injunctions to block that order. Justice Elena Kagan pointed out that so far the Trump administration has lost every case in which this order was challenged, while conservative Justice Brett Kavanaugh questioned the Solicitor General about the practical problems with blocking Trump's executive order in some parts of the country, but not in others.
And then they win. And again, I mean, you need somebody to lose, but nobody's going to lose in this case. It's just you're going to have like individual by individual by individual, and all of those individuals are going to win, and the ones who can't afford to go to court, they're the ones who are going to lose.
The tools that are provided to address hypotheticals like this, again,
this is not a hypothetical. This is happening out there, right? Every court has ruled against you.
We've only had snap judgments on the merits. You know, obviously, we're fully briefing the merits in the courts of appeals, and our arguments are compelling. More fundamentally, in response to the question,
I'm suggesting to you, like the real brunt of my question is, in a case like this, the government has no incentive to bring this case to the Supreme Court because it's not really losing anything. It's losing a lot of individual cases which still allow it to enforce its EO against the vast majority of people to whom it applies.
On the day after it goes into effect, this is just a very practical question how this is going to work. What do hospitals do with a newborn? What do states do with a newborn?
I don't think they do anything different. What the executive order says in Section 2 is that federal officials do not accept documents that have the wrong designation of citizenship from people who are subject to the executive order.
How are they going to know that?
The states can continue to, the federal officials will have to figure that out.
How?
So you could imagine a number of ways that the federal officials could.
Such as
they could require a showing of, documentation showing legal presence in the country. For a temporary visitor, for example, they could see whether they're on a B-1 visa, which would exclude kind of the birthright citizenship in that country.
For all the newborns? Is that how that's going to work?
Again, we don't know.
A little skepticism there from Justice Kavanaugh. Later, when Trump's Solicitor General hedged on whether the administration is committed to abiding by any court ruling, Justice Amy Coney Barrett, a Trump appointee, said this.
Did I understand you correctly to tell Justice Kagan that the government wanted to reserve its right to maybe not follow a Second Circuit precedent, say, in New York, because you might disagree with the opinion?
Our general practice is to respect those precedents, but there are circumstances when it is not a categorical practice, and that is not
this administration's practice or the longstanding practice of the federal government. And I'm not talking about in the Fourth Circuit, are you going to respect a Second Circuit? I'm talking about within the Second Circuit. And can you say, is that this administration's practice or a longstanding one?
As I understand it, longstanding policy of the Department of Justice, yes, that we generally, as it was phrased to me, generally respect circuit precedent, but not necessarily in every case. And some examples might be a situation where we're litigating to try and get that circuit precedent overruled and so forth.
Well, okay, so I'm not talking about a situation in which, the Second Circuit has a case from 1955 and you think it's time for it to be challenged. That's not what I'm talking about. I'm talking about in this kind of situation. I'm talking about this week, the Second Circuit holds that the executive order is unconstitutional, and then what do you do the next day or the next week?
Generally, we follow those.
So you're still saying generally?
Yes.
And you still think that it's generally the policy, longstanding policy of the federal government to take that approach?
That is my understanding.
That is Justice Amy Coney Barrett talking to Donald Trump's Solicitor General. Joining us now, California's Attorney General Rob Bonta. In January, he filed one of the lawsuits challenging Trump's executive order on birthright citizenship and co-leads the coalition against it. MSNBC contributor Mike Barnicle joins the conversation as well. Gentlemen, good morning to you both. Mr. Bonta, so this was the first lawsuit, as I understand it, that you filed against an executive order from this president, something you had been well prepared for. You're on good constitutional ground, as we heard in court yesterday. The 14th Amendment guarantees birthright citizenship, even if your parents aren't citizens. If you're born in the United States, you get citizenship. So we can talk about that part of the case, but let's talk also more broadly about the question that we were hearing debated there about whether a district judge can file a nationwide injunction that extends far beyond the jurisdiction of that court.
Absolutely. This was our first lawsuit of the 22 lawsuits that we brought against the Trump administration in 16 weeks. It was based on a day one action and executive order by the Trump administration seeking to revoke birthright citizenship and amend the U.S. Constitution through the stroke of a pen in an executive order, and that's something you can't do. And you're right, we're on great constitutional ground, whether it be the black letter law right there in black and white in the 14th Amendment Citizenship Clause or the U.S. Supreme Court cases that have interpreted it. Birthright citizenship is bedrock foundational constitutional law. It's a right owed to all in the United States of America. Now, what about the nationwide injunctions? This is a perfect case for a nationwide injunction. It's a constitutional right that applies broadly to everyone in the United States. If you're born on American soil, then you are a citizen, period, full stop. It doesn't matter what state you're born in. If you're born in a red state, you don't get U.S. citizenship because the attorneys general of that state didn't bother to fight for your rights. But if you are in a blue state who did stand up to fight for your constitutional rights, then you do get U.S. citizenship. That doesn't make sense. It belongs to everyone, regardless of the state that you are born in. And so this is a perfect case, in my respectful, humble opinion, for a nationwide injunction. We got 3 of them in 3 different cases, in 3 different district courts, upheld by 3 different circuit courts. So as some of the justices were mentioning in some of the dialogue that you just excerpted, this isn't a close case, and a nationwide injunction is very appropriate here.
General, I'm curious, the other lawsuits you filed, could you give us, in your opinion, which are the ones that you feel are most urgent? Which are the cases, besides the birthright citizenship, where do you see the next big issue coming to fruition in terms of a Supreme Court decision that could impact how this administration is behaving in many ways outside the law?
We have quite a few cases that follow a similar pattern from the federal administration, in which they appear to be a repeat offender, which is that they're trying to stop already congressionally appropriated funding from flowing. In one case, our second case, through an Office of Management and Budget memo that sought to halt $3 trillion with a T dollars of already congressionally appropriated funding for critical, essential programs and services to all the states, about $168 billion worth of funding in California for health care and housing and food and college and child care and public safety, disaster relief. Congress has the power of the purse. Congress can appropriate. Congress can spend. The president can't. But the president wants that power very urgently. It's not his. He can't. And so there's a number of cases in which he has violated the U.S. Constitution, the separation of powers, violated the law, and that issue may go up to the U.S. Supreme Court as well at some point.
Yeah, Mike Barnicle, it does this narrow question about birthright citizenship. It seems pretty plain that you cannot override the Constitution with an executive order. But this larger question about whether district courts can issue nationwide injunctions and stop executive orders from the president was at the heart of what that debate was yesterday during oral arguments.
Willie, at one level, it boggles the mind that we're talking about this being brought before the Supreme Court. And yet, on another level, given the context of politics today in this country, it's not surprising at all. But General Bonta, let me ask you, California would seem to be particularly vulnerable to a change in the birthright citizenship law, given its proximity to an open border. And so could you address that, the vulnerability of your state? But also, if you could take your constitutional hat off, a legal hat, and talk about the politics of it. Where do you sense a movement like this from the administration comes from?
California is the largest state in the nation, and nearly 40 million people. We are a border state. I'll push back a little bit on your description as an open border. But we are a border state. We have about 25,000 babies born every year that are entitled to the privileges and advantages of birthright citizenship. And look, this is a fringe theory that the Trump administration is trying to mainstream. No court has ever agreed with this fringe theory, but it's perhaps a policy proposal that they favor. Maybe some of their base support it as well. And if you want that to be the new constitutional rule of the United States, then go get a constitutional amendment. That's the way to do it. You need 2/3 of the House and 2/3 of the Senate to vote for this constitutional amendment. Then you got to go get 3/4 of the states to ratify it. There's a process. It's right there in the U.S. Constitution. That process is not an executive order issued by the president.
Right, and they have none of those that you just laid out. That's why they're going the route of executive orders. California Attorney General Rob Bonta, thanks so much for being here. We appreciate it.
Thanks for having me.